Kelvin Davis.
Thank you, Mr. Chair. Mr. Chair, the preamble of this bill sets out basically the whakapapa of the bill. And it's important to remember that this all started back when Ngāti Apa were seeking some aquaculture areas way back in the time of the last national government. And the council at the time in the Marlborough Sounds, they wouldn't guarantee Ngāti Apa some aquaculture space. So Ngāti Apa said, well, that's not fair, we're going to take this issue to court. So they did go to court, and finally the Court of Appeal in 2003 said, yes, Ngāti Apa, you may have a case to go to court to test for customary title in court. Now, one of the issues before I move on to other parts of the whakapapa is that just going to court to test that they have a case, Māori have to be really, really careful, because if the court decision says actually you don't have any interest in the customary title in a particular area, then Māori basically lose everything. And that's a point that we all need to realise when we say that Māori are chasing the right to go to court to test for customary title, which I agree with. The point of the matter is that we may lose everything if the Court of Appeal, if the court says no, you don't have a right to customary title in a particular area. And during the select committee process, I actually asked submitters, you're after the right to go to court, yes. Would you accept the court's decision if they said you didn't have a case for customary title? And they said, heck no, we'll fight that, we'll never lay down, we'll never give up another inch of seabed. Now, they say over there, rhetoric, yeah, that's fine, but I know that that is actually the mentality amongst our whānau, is that they won't accept the court's decision if the court says, no, you don't actually have a case to answer for. So it's just something we have to be very mindful of as Māori, that we may in fact lose everything. But that's the risk we take by following this path. So after the Court of Appeal decision, the foreshore and seabed was drafted up. The foreshore and seabed bill was drafted, and we know that was controversial. Here in Clause 2 of the Preamble, it talks about the criticism, and hence the hikoi, led by Hone Harawira, was born, and it started off up north and marched down through here to Parliament buildings. It's interesting, though, that this very issue...
Just a moment. Look, I think we'll permit interjections as long as they're real and reasonable. We're not going to have yelling contests between other members that are dissociated from the member on his feet. Kelvin Davis.
It's interesting, Mr. Chair, that the very issue that gave birth to the Māori Party could also well be its demise. We've seen what's happened to the Māori Party over the last few weeks, where one of the key members in forming the Māori Party is now one of the key members in it falling apart. So it's very interesting, Mr. Chair, that the Māori Party is in dire straits over this. They are embarrassed by this whole bill, and I'll get onto that in a few more things in response to what Rahui Kātane has said just earlier on. So they formed a coalition with the national government, and the coalition agreement said that they would address this whole issue of the foreshore and seabed. And they had the ministerial review, which was fine, and the new bill was produced. And so as a member of the Māori Affairs Select Committee, we traversed the length and breadth of the country. I think we had 14 hearings in various places around the country, and we heard from over 200 submitters. Now, in those submissions, there were the polar opposite views. Māori in particular said that this is a property rights and justice issue, and on the other hand, we had a number of people, mainly from the Coastal Coalition and that ilk, saying that this is a race issue. And it was really unfortunate that somewhere in between the two extremes and the polar opposite views, the truth lies somewhere in between. But I want to just bring up about the Select Committee process, because it was unfair that on Friday before Waitangi Day we received an email on our Blackberries. Those of us who were up north at Waitangi Day, meeting and talking and listening to Māori and hearing what the issues were for Māori, Mr. Chair.
Calvin Davis.
It was interesting that those of us up at Waitangi Day who were mixing and mingling with Māori and hearing what they had to say were emailed on our Blackberries the 500-page departmental report. We spent the whole weekend at Waitangi. Monday we had meetings in our electorates and travelled down here to Wellington to receive the 500-page review on our desks, and we had had an hour or so. There it is. Honourable Shane Jones is holding one up. We had a couple of hours to read that. Now it's impossible to read it, to compare it to the bill, to make comparisons, and to really get your head around it. And it was wrong of the Honourable Tauhenare as chair of the Select Committee to basically rush that process through without due deliberation. It was also unfair and wrong for us to be denied access to legal advice. It was, and when we hear over there Mr. Tauhenare, or Honourable Tauhenare, saying, stop being a crybaby. Well, he knows he's saying that because he knows that he led the process or misled the process of the Select Committee, and so he's embarrassed about that as well. I just want to go on to something that Rahui Kātane brought up. She said, this is a Māori Party bill, this is the Māori Party, and this is the reason they were formed, is to repeal the Foreshore and Seabed Act. So she's very proud of what she's got here, and it's interesting that she says this is a Māori Party bill, because I've got here in my hand a newsletter or a letter from a Māori Party member who attended one of Te Ururoa Flavel's sideshows. When he went around the country trying to convince Māori Party members that this was a good thing. And he no doubt told them what he wanted them to hear. But the question was asked, who is running the timetable? And Te Ururoa said, National. Who wrote the bill? National. Whose bill is this? Nationals. It's not the Māori Party's bill at all, so why the hell vote for it? This is what his name is... Sorry, I'll just get to the end of the scroll to the end. Tim Selwyn. So he is, was, I assume, a Māori Party member, and he's saying that this is not a Māori Party bill, this is a national bill. Now, somewhere between Rahui Kātane and Te Ururoa Flavel, they need to sort out just whose bill exactly this is. Because Rahui Kātane is saying it's a Māori Party bill, we're very proud of it. Te Ururoa Flavel turns up to a public meeting and he's saying he's washing his hands of it, he's doing the old Pontius Pilate, he doesn't want any part of it, he's saying that this is a national bill. Now, sort it out, I say, between them, because there's just more confusion arising from this whole episode. So, Mr. Chairman, that really is the bones of the whakapapa regarding this bill. It was actually well explained and well set out by John Boscawen there from the ACT Party, I do agree it's a bit hard when a Labour Party member and an ACT Party member actually end up agreeing with each other, but I also do agree that there were times when I thought the chairperson of the Select Committee was actually a bit rough with a number of submitters, and I agree with the Honourable John Boscawen that when public members of the public come and express their ideas at Select Committee, they shouldn't be put down or harangued or harassed in any way, and that was a shame that happened. Even though I was quite blown away by some of the extreme views of a number of the people who from the Coastal Coalition who say that this bill is about separatism and apartheid, and that they are nuts. And I think that they need to really pull their heads in, because they're basically so extreme that they're actually not helpful at all to any part of this whole debate. So with that, Mr. Chair, kia ora.
Paul Quinn.